Hello, good afternoon and welcome to the 30 Park Place Welsh Education Law Conference 2021. My name's Emma, I'm the editor of Legal News Wales and we're the host platform for the event today and for next week. I'd just like to run through a little bit of housekeeping for you all as you join the event, which you'll notice is a webinar. So firstly, that is different from a Zoom meeting in that we can't see you, but you can see us. And we'll make sure that you can hear the speakers nice and clearly because they'll stay on mute when they're not speaking. We are recording the event, which again is more for us than you because we won't see you, but you'll know that we can share the recording, both recordings later on that could be passed around your colleagues. And also if you have something urgent to attend to, you've got the knowledge that you can dip back into the recording at a later date. And we will be organising any further supporting slides and notes, etc. And get those out to you via Chambers. So there are a couple of ways of interacting with us. Hopefully we have some time for a Q&A session later on, and we can allow you to obviously engage with us through the Q&A function. So there should be a double bubble on your icon on your screen. If you're coming in through a phone, you'll still have that Q&A option available to you. You can type a question in the knowledge that no one else is going to see other than the panelists what you're writing. So there's no question, great or small, that you can send in. Obviously it's a bit of a free-for-all, and any points that you'd like to make as well. If you have a question for a specific speaker, please do mention their name as you're writing that, so we can direct that to them. And if we run out of time, obviously we can pick that up offline later on and perhaps even come to it next week. I think that that's just about it from me. I would like to pass over to Mark Allen, who's chairing the event, and he is head of education law at 30 Park Place. My thanks again to Chambers for inviting us to host it, and I hope you will enjoy this afternoon. Thank you.
Thank you very much, Emma. Croeso, welcome to WELC 2021. I'm sorry we missed 2020. For obvious reasons, but we're back now for 2021. Thank you all for attending. It's a shame that we can't see you all in person and have lunch with you, but that's the difficulties we're living with. But at least I don't have to tell you whether there's a fire drill or where the toilets are. I hope you know. This year's event is also free, but we have asked for a donation to charity. The relevant charity that we have chosen is Snap Cymru, obviously as an education charity in Wales. I know that there have been difficulties with making a contribution, but we have now set up, or I think Emma set up, a Just Giving dedicated line. Details have come out to you, or we can supply them. Please do make a contribution to their funds. I should say, just to underline it, that of course all of our speakers have contributed their services for free. The talks we're about to commence are designed to be short reminders of the new legislation and to focus on the main points. Time is limited, and so this is not an in-depth analysis, and I'm afraid it just cannot be an in-depth analysis because of the limitations. If there is time, we will take questions at the end, as you've heard. Please type them in, and we will do what we can either during today's webinar or thereafter. We begin with Laura Shepard's overview of the new legislation and its implementation. I appreciate that there are some queries at the moment about implementation, and we're all waiting to hear what the final position is. Then we have Melissa Jones, who's going to talk about what schools have to do. And then Laura comes back with what local authorities have to do for her further talk. And then just so that you're aware, there are more talks next week. They will cover the role of additional learning needs coordinators, as they are now going to be called, and educational psychologists. Those I think are particularly important for the new legislation. Also the impact on parents, the impact on further education institutions, the impact on health boards, and the new education tribunal regulations, which I'll talk about right at the end. So all of that is next Wednesday, same time, same channel, as they used to say. And I'm now going to hand over to Laura.
Good afternoon, Pranam Da. I'll share my screen with you, everyone. Okay. We should all be able to see it now. So at this stage, I'm just giving the overview, focusing on the key points that have come about as a result of the new legislation. Mark has already outlined the sort of plan for this afternoon. I'm going to be giving my brief overview. Then we're going to have what schools have to do. Then unfortunately, you're going to have me again, and I'll be doing what's going to be the impact on local authorities. The key materials, I would say at this stage are it's the Act itself, firstly. We have some tribunal regulations, albeit we've had a lot of regulations come through fairly recently. And I think probably the most comprehensive document that covers most areas is the code, statutory code. So we have to abide by it as well as the legislation, because it has that effect. And I think that's, as I say, it's the most comprehensive document, and it does include information from the Act as well. So I'm going to start with children first, and go on to implementation. So we were supposed to be having implementation fully in 2020. So we were supposed to have it in September 2020. It's been pushed back now to September 2021. So this is the new D-Day, hence my stupid picture. So the new ALN system is expected to go live this September, and it's not going to be a straight in there, all guns blazing, all in one go. There's going to be a phased implementation, which is going to last 3 years. So we're finally going to be in a position where all children and young people are going to be under the new system, hopefully by 2024. So during that time, the existing statements are going to be used and converted into individual development plans. And that's going to be on a mandatory phased approach on the basis of particular age-based cohorts. So I don't think as of yet, or I haven't seen it yet, that we've got information as to which cohorts are going first. But we're going to have some cohorts that are going to be on the new plans, and we're going to effectively have a two-tier system where some people are going to still be with their old statements or individual education plans at a school-based intervention level. So at this time, we're going to have the two systems running parallel to one another. I've taken this from the WelshGov website. This is just a sort of chart showing us sort of where we are in the implementation timeline. And at present, we're in, I suppose, the spring 2021 stage. We've had the, which is just down here, it's bottom centre. We've had the code, we've had some regulations. They've been laid before the Senate for approval, and we've had them through in March this year. And that's now going to be in the run-up to implementation in September. We had a whole raft of new statutory instruments made in March of this year. We had the additional learning needs code made under the Act. And I would say that's a really good starting point, because it does lay it out in fairly simple language, and is quite comprehensive, and focuses each chapter on a different type of child or young person. So depending on a specific person's circumstances, they'll have their own separate chapter within the code. We've also got the ALN regulations, the Tribunal for Wales regulations, which Mark is going to talk about next week. The Equality Act 2020, capacity of parents and persons over compulsory school age Wales regulations. So it does touch on capacity, but I still think there are probably some more questions in respect of young people who lack capacity. We've had the independent schools regulations, which is going to be particularly important for local authorities, because under the new code, local authorities take over a lot of responsibility for the maintaining of individual development plans for children who are independent schools. And then we've also had the PRU regulations through as well. So at this stage, I just want to go through the 11 key changes. So it's going to be fairly broad brush, and just the key differences that you're going to see between the old system and the new system. The first one is the introduction of the new terminology. So previously we were SEN, we're now going to be ALN. There's a new range. There's going to be a single legislative system for children and young people between 0 to 25 years. So that is, instead of the two systems that we currently have, we have one system operating to support children and another system for young people over compulsory school age. So that new system replaces the existing support plans. It doesn't give young people with ALN a right to continuous education up to the age of 25, but it's more about providing access to educational training on an equitable basis so that young people who have ALN aren't disadvantaged. So moving on to the key changes 3 and 4, we've now got this single statutory plan. So this is going to bring an end to the system where we have at the moment between school-led interventions, so your school actions and your school action plus and your individual education plans. And then when you move up to local authority involvement with your statement, that system is going to end, and all children with additional learning needs who have been assessed under the statute are going to have an individual development plan. So we're just going to have that one single plan, and in the code, one of the annexes to the code has got like a format for that plan that should be followed and sets out the various different parts of it. So I would say that a good place to start with the IDP is to look at the code and to look at that pro forma, because that's going to help, I think, in terms of understanding the setup of it. But I think the key message to take away is we're no longer going to have the different types of intervention. It's just going to be the IDP. And then the other key change is there's supposed to be increased participation of children and young people, requiring that learners should always be considered as part of the planning process, along with their parents and carers. Now, I don't think it's being suggested that that doesn't happen now, but I do think that the new regulations, particularly with regards to young people being able to bring their own challenges, is quite a difference to what we see at the moment. In terms of the next couple of changes then, high aspirations and improved outcomes. So the emphasis will be making provision that delivers tangible outcomes that contribute in a meaningful way. And it's supposed to be a simpler and less adversarial system. I think a particular difference there is in the legislation. There's a change from the local authority having a duty to resolve disputes, and the wording has changed now so that it's the local authority under a duty to help resolve disagreements. And I just think that is maybe I'm being pedantic in terms of the words, but I do think that is a slight difference and a slight change in terms of how things are being approached, that we're trying to resolve disputes from an earlier stage. Increased collaboration is another aim of the new legislation, to encourage information sharing, particularly between public bodies, health boards, local authorities, and it's hoped that will help that needs are identified and the right support is put in place to enable children and young people to achieve positive outcomes. And again, coming back to this point of disagreements and disagreement resolution, it's no more disputes, which I think as a word indicates that it's more preparatory to litigation as opposed to simply a disagreement, which can be much more informal. And it's hoped that can be resolved at a local level without having to go to the tribunal. There will also be clear and consistent rights of appeal. So in the Act, there's a section where it sets out each different route of appeal to the tribunal, which can include the contents of an IP, the fact that a local authority hasn't prepared an IDP. There are various different, but it tends to be the focus on the IDP. In the same way as now we can challenge a statement, it's a similar route of appeal, but they're just set out really clearly in terms of the different routes. And then we've also got the Aln Code, which again, I would say is very comprehensive, much more comprehensive than the 2004 code that we're working from at the moment, and really sets out enforceable parameters within local authorities and other organisations responsible for the delivery of services for children and young people with ALN. And finally, a bilingual system. This is an act that requires that consideration must be given to whether additional learning provision should be provided in Welsh, and that must be documented in the IDP. In fact, in one of the sections of the IDP, communication is a clear section, communication needs. And so that's something that should be recorded within the IDP. And all reasonable steps must be taken to secure the provision in Welsh, should that be required. So just to recap, really, I think these are the key points. We're replacing the old SEN system with the new ALN system. We're making provision for this universal statutory document called the IDP, which goes from 0 to 25. And these plans are for all children and young people with additional learning needs. So we don't have the difference as we had before between the learning disability guidance for people over 16 versus the mandatory school age provision that we had in place before. So we're going to bring an end to that distinction between school-led interventions and local authority issued statements, and integrate the separate legislative arrangements that exist at the moment. And the Act also seeks to improve collaboration between local authorities and health boards, as well as establishing a fairer and more transparent system with a greater emphasis on disagreement avoidance and dispute resolution. So I've done a Q&A at this stage. So if anything has come up, I think in that talk, I think it's best to put it in the Q&A box either now or when the question comes to you. And I think what's going to happen is that the questions will be fed to us. We will consider them, and then hopefully there'll be some time at the end so that we can have a more interactive part of the talk. But thank you ever so much for listening, and hopefully speak later. I'm going to hand back over to Mark now.
Thank you. And I'm going to, without wasting any time, hand straight over to Melissa, please.
Thank you, Mark, and thank you, Laura, for that excellent overview. I'm just going to share my screen now so you can all see the slides. So hopefully this works. I'm hoping now you'll have the title slide. I can see some nods, so that's very helpful. So what I'm going to talk to you now in terms of a whistle-stop tour of the new legislation is what schools have to do, including fee-paying schools. And rather helpfully, it's set out in terms of the Act, Section 11 and Section 12, and we'll look at those in more detail in just a moment. And in terms of the code, Chapter 9 and Chapter 10, which relate to maintained schools and further education institutions, respectively. In terms of Section 11 of the Act, this sets out the duty to decide. So what this essentially means is that where a governing body of a maintained school or a further education institution it comes to their attention, or they're made aware that a child or young person who's registered at that institution may have additional learning needs, it needs to decide whether they have additional learning needs and how they can then facilitate them being supported. And the caveat to this is any of the circumstances in subsection 3 of section 11, and if those apply. Now, those caveats of circumstances in which the duty to decide wouldn't apply, they're as follows. So where an IDP is being maintained for the child or young person, where the governing body has previously decided whether the child or young person has additional learning needs, and the governing body is satisfied that firstly, their needs have not changed materially since that decision, and secondly, that there is no new information that materially affects that decision. So of course, if either of those things aren't in place, then there would need to be a review of that decision to see if anything has changed and if anything further needs to be put in place for that individual. The third circumstance would be when a decision is made about a young person and the young person doesn't consent to that decision being made. Fourth caveat is that the child or young person is registered as a registered pupil or an enrolled student at another institution, and a local authority is responsible for them. And Laura will talk more about the local authority's responsibilities later on today. The final caveat is where a local authority in England maintains a plan for the child or young person, because it would therefore be their responsibility as opposed to those operating in Wales. So those are the circumstances in which the duty to decide is effectively mitigated. But in all other circumstances, the school or the further education institution would be required to consider whether or not the child or young person has additional learning needs and what to do moving on from there. Section 12 of the Act relates to the maintained schools or further education institutions and their duty to prepare and maintain IDPs, which is the document which Laura's helpfully referred to, and set out the parameters of that. And so if a governing body decides that under Section 11 that the child or young person has additional learning needs, it must then prepare an individual development plan for them, unless any of the circumstances in subsection 2 apply, and it also must maintain the plan unless the circumstances in subsection 2 apply. So turning then to section 12, subsection 2, and the circumstances in which a school or a further education institution wouldn't need to prepare and maintain the IDP, those are as follows. Where the governing body considers that the child or young person has additional learning needs, it may call for provision. It would not be reasonable for the governing body to secure, or the extent or nature of which the governing body cannot adequately determine, or for which the governing body cannot adequately determine provision, and the governing body refers the child or young person's case to the local authority responsible. And so what that means is if the further education institution or the maintained school isn't able to determine or provide or secure the level of provision that's required for that child or young person, they can then refer it to the local authority under section 13, subsection 1 of the Act, for the local authority to then consider. And so that's one of the options available then to those institutions if those provisions are met. And so that's kind of the interplay between the local authority and the maintained schools and further education institutions. So there is, as Laura's already said, a collaborative approach between all parties in terms of these decisions being made, and making sure that there is that transparency and there's that communication and those channels remain open to ensure that those decisions are made in tandem. The other circumstances in subsection 2 of section 12, where the plan is about a young person who does not consent to the plan being prepared or maintained, the government body requests the local authority in England to secure an assessment, and that local authority is then responsible for them, or where a local authority in England maintains a plan for the child or young person. So those are some of the other situations in which there wouldn't be a duty to on the part of the school or the further education institution in those circumstances. Section 12 goes on to make a number of other points and gives further guidance and further information about the remit of schools and further education institutions. And so subsection 3 relates to where a governing body of a maintained school has been directed to prepare and maintain, or to maintain an individual development plan for a person. They must prepare and maintain that plan unless the circumstances in subsection 2 apply, as just gone through those. So there is a duty to ensure that that is prepared and maintained in accordance with the legislation and that individual's needs. Subsection 4, where a government body of an institution in the further education sector has agreed to request under section 36, subsection 2, to become responsible for maintaining an individual development plan for a young person, or where the Welsh Minister determined under section 36, subsection 4, that the government body should maintain the plan, the governing body must maintain that plan unless the circumstances of subsection 2 apply. So again, where they've agreed to become the responsible organisation for maintaining that IDP, or where they've been asked to do so by the Welsh ministers, that is then an obligation on them to ensure that that's undertaken. Subsection 6 goes to one of the points that was raised by Laura and the need for a bilingual system. A governing body that prepares or maintains an IDP for a child or young person must consider whether or not the provision should be provided to the child or young person in Welsh. And if it decides that a particular kind of provision should be provided in Welsh, it must specify in the plan that needs to be done. So it's crystal clear that provision should be provided in Welsh, and that's part of the assessment of how that will assist that individual. And finally, subsection 7 to section 12 indicates that a governing body must secure the provision described in an IDP that it maintains under that part of the Act. And so if the plan specifies that a particular kind of provision should be provided in Welsh, again, it must take all reasonable steps to secure that it is provided to the child or young person in Welsh, and to ensure that the provision is provided as described. So in terms of summarising the key points relating to those sections of the Act, schools have a duty to decide whether a child or young person has additional learning needs, and the same goes for further education institutions. If a governing body determines that a child or young person has additional learning needs, then they have a duty to prepare and maintain the IDP. Section 13, subsection 1 can be summarised as if the governing body for a school or a further education institution cannot adequately determine the provision, the governing body can refer the child or young person's case to the local authority responsible so that they can then make a decision. As highlighted, the governing bodies need to consider whether or not to provide the provision in Welsh, and as Laura's already indicated, the new system very much puts the learner at the heart of everything that happens, and there's an expectation in the legislation that schools and further education institutions will take a person-centred approach when planning for and supporting children and young people. And as Laura's already said, that's not to say that that's not already taking place, but that's a real focus in terms of the legislation, to make sure that that's kind of the attitude that's adopted, and to ensure that there's collaborative and cohesive working between all people who are involved. In terms then of other points to note, and it may be that this is touching upon some of the things that Laura's already mentioned, and also things that might be dealt with in next week's talks. The Act doesn't give young people with additional learning needs a right to continuous education up to the age of 25, but it is about providing opportunities, and as already been said, that's to ensure that they're not disadvantaged as they go through into young adulthood. But one of the things to note is that if a learner is undertaking work-based learning or an apprenticeship and is enrolled as a student at a further education institution in the course of that employment, the duties on the further education institution do apply to that individual. And if that young person agrees for their IDP to transfer with them to their higher education institution or their work-based learning provider or apprenticeship, it can be used for transition and to support planning. So there continues that through process to ensure that they're well supported going on and going into the next stage of their education provision. Just touching briefly on the relevant timeframes, in terms of the code, and of course it's still in draft form at the moment, the proposal is that a school must prepare the IDP promptly and in any event within 35 school days from when it has been brought to their attention that the person may have additional learning needs, or if a pupil has consented to that decision being made. So it's a 35 school days, so it's a quick time frame, and the proposal really is to ensure that no child or young person with additional learning needs goes for much longer than a whole school term without an IDP being put in place, and similar timeframes are imposed on the local authority, I think 12 weeks. So those are the obligations on the school in terms of making sure things are expedited and done quickly to ensure that that child or young person is supported appropriately through that process. In terms of the code, as has already been touched upon, there's a standard format, and there's going to be examples given within the code. The form style might be adapted to suit the local preferences or those of the child or young person, but because of the provision that it contain key elements and have the same basic structure. And really this is to promote consistency and equality in terms of the way that learners are treated, and again kind of aids the consistency and the cohesion within the whole system. Just considering local authority maintained IDPs versus school maintained IDPs, the reality is that these both have exactly the same statutory standing, and whichever body that prepares and maintains those documents must ensure that it describes the child or young person's additional learning needs and the provision that's required, and then must secure the provision. Chapter 9 of the Code provides clarity on when a school should refer a pupil to a local authority for it to decide whether or not the pupil has additional learning needs, and to decide whether the local authority or the school should have responsibility for maintaining the IDP. And it offers guidance as well to local authorities on how they should determine whether it's reasonable for a school or the local authority to secure the additional learning provision required for that child or young person. And so again, this is just pointing to the interplay between those organisations to ensure that there is that communication and those channels do remain open and are well utilised. Touching briefly then on fee-paying schools. If a local authority places a child or young person with additional learning needs at an independent school for the purpose of receiving specialist provision, the local authority would then continue to maintain the IDP. Where it's brought to the attention or otherwise appears to a local authority that a child attending an independent school may have additional learning needs, it would be for the local authority to determine whether they have those additional learning needs, prepare and maintain an IDP for them if they were considered to have those additional needs and require that specialist provision. In the case of a young person in the same circumstances, the local authority would need to decide whether or not it was necessary to maintain an IDP to meet their reasonable needs for education and training. And so it's a slightly different situation where the local authority very much has a fuller involvement in that process when it comes to fee-paying schools and independent schools. There are just some fact sheets here which have been taken from the Welsh Government website, and when these slides are shared with you, they just go over and highlight the key points relating to the impact on schools and further education institutions. And so it effectively summarises what's been said already, and it's a helpful sort of fact sheet guide for the new legislation and the new code as well, and the regulations. Thank you very much for listening. And of course, if there's any questions, it may be that towards the end of the session might be a more appropriate time, but please do let us know. But thank you very much. I'm going to hand back to Laura now for her talk about the impact on local authorities.
I've had a couple of questions come through, and I think now might be a good time actually just to very quickly address those. I'm going to keep the identity of the people who've asked the questions, like I'm just going to say the question. So the first question is, for those pupils who currently have a statement, will all of the information in this document need to be transferred to the new IDP? So I would say that effectively an assessment for an IDP is effectively a fresh look at the child's additional learning needs. Nevertheless, what I'm going to do now is I'm just going to share what I was talking about in terms of the pro forma. This is the standard form. So if we look at this form, in practical terms, a lot of the information which is in a statement will likely be the same as what's in here, but there are specific, it's a specific way of presenting the information. So you've got the basic biographical information, who's responsible for the IDP, a profile which is just sort of like a pen picture. So at the moment we don't have, for example, a pen picture in a statement. You've just got parts 1 to 4. And then part 2, which is, I would say, very similar to the part 2 of a statement that we have, the description, the ALP to be provided, the intended outcome. And it's like, as I said in my talk, is outcome based, as where I think in the part 2 statement at the moment, it's not quite as outcome based, it's much more sort of like almost like a stating of diagnoses, for example, if there are any. And then just flicking through again, sorry, part 3, this is, again, I would say different information that we don't have in a part 3 of an SEN statement. Transition, travel arrangements, and then this is a different form for a looked after child. So overall, I would say, in one sense, in reality, it's a similar type of document trying to do a similar type of job, which is to provide a guide for people so that everyone can understand what provision is being provided to a specific child or young person. But I think the focus of this document does focus the information in a slightly different way. And in any event, I think when a new IDP is put in place, it's likely to trigger a fresh look at the level of need. I'm just going to stop sharing there for 1 second. I had another, someone else asked, said the Welsh language duty is not linked to the ALN category of speech, language and communication. The code is clear that the simple fact that the school doesn't speak Welsh whilst attending a Welsh medium school will not constitute an ALN. I completely agree with that. I think we may be talking at cross purposes here, so I'll just show again what I meant. So in terms of the communication is at 1A10, communication requirements and preferences. And I would say that is different to, for example, should the ALP be provided in Welsh? I think that is a slightly different question. So what I meant is there's a communication box where I think requirements and preferences, I think Welsh language is a preference in terms of communication about the ALN, but then whether the ALP should be provided in Welsh, again, I think is a separate issue. And I completely agree that not being able to speak Welsh does not amount to additional learning needs. I think we may have been talking at cross purposes, or maybe I didn't express myself clearly enough, but I think we're agreed on that issue. I'm just going to see if there are any more questions for me. Okay, I think I'll do one more question before I start my talk. So someone has asked what level of learning need will be considered necessary to require an IDP. The answer is if you assess a child and if the duty to assess, duty to decide is the new language. I'm sorry, I'm still trying to get used to the new language myself. If the duty to decide and you decide that a child has additional learning needs, you then have to prepare an IDP. The detail provision is going to be different and child specific. So a child with a wide level of needs, so for example, someone who is non-verbal, etc., and has both physical disabilities and learning difficulties, they are going to have probably a more extensive IDP than someone, for example, who has a different level of need and doesn't need as much provision. Okay, so at this stage, I'll go on to my talk and maybe we can come back to some more Q&As later. Okay, so the impact of the new legislation on local authorities. This again, I've taken from the Welsh Gov website. And this is just, again, I think those 11 key changes that I spoke about earlier, I think this fact sheet just sort of summarises them. And I've got the Welsh language version here as well. I'm not a Welsh speaker myself, but I did my best to try and make this presentation as bilingual as possible. So this just outlines again in very brief sort of infographic format the key changes that are going to be made into the new legislation from a local authority perspective. So the Act places a range of duties on local authorities in relation to additional learning needs, and I think the main groupings can be specific duties. So this is in relation to individual learners, for example, the duty to decide, the duty to maintain an IDP, and then more general duties. And this is more in terms of the system as a whole to ensure its functioning and effectiveness. So starting with some of the general duties, and these are just a few that I've picked out from the legislation that I think are probably the sort of key things to focus on. The duty to involve and support children, their parents and young people. That's in section 6 of the Act, and the specific chapter of the code that covers that duty is chapter 4. The second general duty is the duty to have regard to the United Nations Convention on the Rights of Persons with Disabilities. Again, that's sections 7 and 8 of the Act and chapter 5 of the code. Duty to provide advice and information, and that's section 9 of the Act, chapter 6 of the code. And duty to keep additional learning provision under review. So that's provision in a local authority area as opposed to with regards to a specific child. Going to start with children first in terms of the duties in relation to children, because as I say, this, although we've got the 0 to 25 age range now, there's slightly different tests and sections in relation to children versus young people. So the first is the duty to decide whether a child has ALN. And it's very similar, again, to what Mel outlined in respect of schools, and it's where it's brought to its attention or otherwise appears to a local authority. So that, I think, is a very, very low bar. Effectively, if it is brought to attention, it can be in any way, I would say. It doesn't necessarily have to be something formal, because I think the legislation is drafted as such. For whom it is responsible, again, I think we're getting into sort of ordinary residence type issues there, and there's provision again within the Act as to what as to when a local authority is responsible for a specific child. The local authority must decide whether the child has ALN unless one of the following circumstances applies: an IDP is already being maintained, and or the local authority has previously decided the issue and is satisfied that the child's needs have not materially changed since that decision, and there is no new information which materially affects that decision. So as I say, quite a low bar, so it's quite an onus on local authorities in terms of the duty to decide. Again, there are provisions within the Act, and it's quite complicated actually, because there are times when the local authority can pass duties down to a school and vice versa, but it is, I would say, quite an onus, because as I say, the bar is quite low in respect of when it's brought to its attention or otherwise appears to. That duty to decide kicks in. Then we've got the duty to prepare an IDP, which links into the question that was asked earlier. So if the local authority decides that the child has additional learning needs, it must prepare an IDP for the child. And in terms of the following circumstances, these are just because the tests and the legislation is slightly and subtly different in relation to different children in different circumstances. So where the child is under compulsory school age and not in a maintained school in Wales, chapter 11 of the code, where the child is of compulsory school age and in a maintained school in England or Wales. However, in that circumstance, the local authority can direct the school to prepare and maintain the IDP. Again, there is provision for a bit of sort of back and forth, I would say, between the school and the local authority. The other circumstance where it's the local authority is where the child is of compulsory school age and is not at a maintained school. So if the child is at a fee-paying independent school, the duty is on the local authority to prepare the IDP. And finally, where the child is a looked after child, the duty is with the local authority in respect of IDPs. So we've gone past preparation, and now it's the maintenance of the IDP, because there are review provisions again within the legislation. So where the local authority has prepared an IDP for the child, it must maintain it. In some circumstances, the local authority may instead direct the school to maintain that IDP. And again, those circumstances are set out in the Act. But I would sort of say at this stage, again, I'm sort of a bit wary of going into too much detail at this stage, because it is intended just to be a fairly broad brush presentation at this stage, and it does depend on, again, the specific circumstances with relation to the child. Okay, so you've got the duty to provide the IDP, maintain it, and now secure the additional learning provision which is outlined in it. So where a local authority maintains an IDP, it must then secure that provision. For example, if that's a place at a different school or within the current school, but just specific provision, the local authority must secure it. Okay, so I've left behind children, now we're going to go on to young people. So again, it's the same test with respect to young people, where it is brought to its attention or otherwise appears to a local authority that a young person at a school and for whom it is responsible may have ALN, the local authority must decide whether or not the young person has ALN, except in the following circumstances. So again, it's slightly different in terms of the different circumstances for a young person as opposed to a child. So the circumstances are where an IDP has already been maintained, where it's previously decided the issue and satisfied that the young person's needs have not changed materially. So those are the same two circumstances as we had with children. Thirdly, where the local authority is satisfied that the question of whether or not the young person has ALN is being decided by the school or FEI, or where the young person does not consent to the decision being made. Now, I think that final one is where it gets quite interesting. And I referred to the capacity regulations earlier, but I don't think that those regulations really touch on this particular issue of consent, where a young person is over the age of 16 and has been assessed to lack capacity, and whether they, what we mean by consent in those circumstances, I think is going to be an area where we might have some case law come through. We may have some issues there, I suspect. Just pausing for a second on the Welsh language slide, because I couldn't fit all of this into the one slide. I do apologise. Okay, so again, mirror image provisions with respect to young people, the duty to prepare an IDP, where a local authority has decided that young person at a school and for whom it is responsible has ALN, it must either prepare an IDP or direct the school to prepare and maintain an IDP. If the local authority prepares an IDP, it must then either maintain it, or if the local authority considers it appropriate, direct the school to maintain it. The exception to all of this is if the person does not consent to the IDP being prepared or maintained. So again, subtly different with respect to young people as opposed to children, because we've got that consent issue again, and we've also got the provision which is similar to with respect to children, is that the local authority can direct the school to prepare and maintain IDPs. The duty to maintain, so where it's prepared it must maintain the IDP, except in the following circumstances: where it directs the school to maintain it, or where the young person does not consent to it being maintained. And again, mirror provision with respect to schools and children, where a local authority maintains an IDP, it must secure the ALP within it. So disputes and disagreements, finally. Again, I think this is what I was referring to earlier, Section 68, very subtle change in the words from the previous legislation where it was disputes. Local authorities must make arrangements for avoiding and resolving disagreements. Again, I think there's a subtle difference there. Disputes being with a view to litigation, I would say. Disagreement being much earlier in the process and being much wider in its within its scope. So must resolve disagreements between education bodies and children and young people for whom the local authority is responsible, and in the case of children, their parents, about the exercise of the body's functions under Part 2 of the Act. So even though disagreement is quite a broad word, it is obviously focused on the duties within the Act. And in terms of the arrangements for the avoidance and resolution of disagreements, local authorities must also make arrangements for avoiding and resolving disagreements between the proprietors of the institutions and the children or young people who have ALN and for whom the local authority is responsible, and in the case of children, their parents. With regards to independent advocacy services, local authorities must make arrangement for the provision of independent advocacy services for the children and young person for whom it is responsible, and refer any child or young person for whom it is responsible who requests independent advocacy services to an independent advocacy service provider. And I think local authorities tend to they tend to have this information. They tend to have a list of providers. In this, it's sort of similar, I suppose, looking at adults. You have advocacy providers for adults, and you also have advocacy providers with regards to education as well. And they also must refer any person who is a case friend for a child for whom it is responsible. So case friends really do relate to when we're getting more into bringing cases before the tribunal. And I think Mark will probably be touching that on case friends more next week, because this is something that's quite new, this idea of a case friend. And so the case friend can also be referred to independent advocacy services as well, because they occupy, I think, a special place in all of this. They're not necessarily an advocacy provider. It's more of a sort of litigation friend role, really. And then again, we're back to Q&A after that fairly whistle-stop tour. So I'll stop sharing and just take a few moments, I think, to have a look at some of the Q&As while I hand back to Mark.
Yes, while you're doing that, Laura, could I just say that as ever with this conference, we have a wonderful audience who raise a lot of really interesting questions. And there are a bunch of questions which have been raised, which are not only interesting, but some of them quite technical, I suspect, as well. One easy one is, are the PowerPoint presentations going to be available? Yes, I can answer that one. But there's a number of other questions which are quite difficult. So I don't know if my colleagues can have a look through as well. And we'll see if we can find some that we can take now, because we obviously have some time to do so as we've rattled through the presentations. Can I just invite my colleagues, anyone that wants to dip in, please do.
I'm going to dip into a couple. I just need a couple of moments just to get the relevant references, if that's okay. Absolutely.
One question I see is this: when would you expect that Welsh ministers direct a school to maintain an IDP? That is a really interesting point, and it's one of the issues which arises under this legislation and the code in terms of who's going to end up doing what. There is undoubtedly room for conflict between schools and local authorities, and sometimes conflict arises now about provision in particular, and who's going to make that provision. But it seems to me that there's plenty of scope now for that to become increased. And especially since so much responsibility is going to be laid at the door of the new Aln Code. But in terms of when can that referral be made, it seems to me that it's most likely to be made when there has been a dispute between a local authority and a school, that is then the minister's asked to intervene with that. But in addition to that, it seems to me that, well, I know that under the tribunal regulations, one of the things the tribunal can do is refer matters to the minister. And so that's another route or another reason why the minister might become involved and effectively give direction to a local authority. So there's two answers, but I suspect that there will be other matters which we will find out about as time goes on, because we're all learning, obviously, as this goes through. Right, Laura, do you have anything at the moment?
Yeah, so I've got one question here which says, if parental preference is to send their child to an independent school, so a school not maintained by the local authority, if additional learning need is disputed, will parents be able to appeal to the tribunal if it is disputed? So yes, Section 70 of the new Act contains all of the different matters about which an appeal can be made to the tribunal, and it's Section 70 subsection 2 F. So the school named in an individual development plan for the purpose of Section 48, yes, that can be appealed to the tribunal in the same way that Part 4 of an SEN statement can be appealed in the current regime. So yes, if the parents feel that there's a school which better meets the need than the one which is named by the local authority, and that is an independent school, then the right to appeal will still apply.
Okay, Melissa, is there anything that you have spotted that you can answer?
I'm just having a little scroll through.
Okay.
Someone's asked, will the referral process remain the same with regards to requesting LRB or specialist placement? The answer to that is I actually don't know, because none of the legislation provides any, for example, forms. So at the moment, the local authority have their forms that they use for parent input, etc. I haven't seen any new forms, but so I don't know at that stage. I'm going to have another look to see if there's anything in the code which does refer to the referral process. But at this stage, I'm not sure that either we've got any new forms in terms of referral forms, or whether it's going to fundamentally change. But I would still say that the duty is there for a local authority or school or FEI to decide whether a child has ALN. And again, that decision is appealable to the tribunal.
And can I go to another question? And it's this: there's a huge responsibility on the shoulders of the governing body. What is the governing body? It's pointed out, volunteers, unpaid, and in many instances inexpert, do not have the competence or capacity to determine whether a young person ought to have an IDP or what ought to be included. What are the mechanisms in place that feed into the process to enable the governing body to facilitate this process to an extent that they may fairly be held accountable? I think the answer is you have to ask for help from the appropriate places. One of those obviously is going to be the Aln Code, as I'm sure everyone's familiar with the SENCO process, where we're going to have an Aln Code who is responsible for being the first person who's got to look at these issues. And if the Aln Code, it seems, feels out of his or her depth, then I think you go to the local authority and you ask for some help, again, just as you would at the moment, whether it's from one of the expert teaching panel, which is usually available in local authorities, or educational psychologists. One of the interesting things that the local authority is now going to be required to do is if they consider that a particular child or young person has additional learning needs, they must consider whether they get advice from an educational psychologist. And I'm very pleased to hear that's been beefed up, because of course that wasn't the position initially. So I think the answer is it is not intended that governing bodies make these decisions when they don't have the capability to do so. You have to ask for the help from the right people. There are qualified staff at the school, and if necessary, you move on to qualified staff at the local authority. And it may be, of course, that an individual child should have its IDP written by the local authority anyway, because it's a case which is a sufficient magnitude to take it off the old school action or school action plus up to what used to be the statementing level.
I'm happy to take on the next question, which is it really the intention of the legislation that LAs will be responsible for maintaining the IDP and making the ALP for children in fee-paying schools who have mild to moderate ALN? Surely this is inequitable. I don't think I can sort of comment too much on the legislation other than to say that is quite clear, I think, within the code. I don't know whether anyone else agrees with me, but that's what the code says, is that if that circumstances, it's a local authority maintained IDP. So I'm just seeing if I can have a look at some of the explanatory notes, because that may provide some reasoning, or we'd have to, I think, look at the documentation. But that is the intention of the legislation. It is fairly clear, I would say, in terms of the duties that are on local authority in that regard. Whether it is inequitable, I would say is a matter for discussion, but I don't know whether it's one that I can sort of comment on at this stage.
Can I just add one interesting thing to that? And that is that the Act, of course, states very clearly that local authorities, schools, and in particular fee-paying schools cannot charge for the provision of additional or to meet additional learning needs. And so we all know, I think, of schools who will add a bit to the fees because they're providing some extra teaching, whether it's to do with very commonly dyslexia or something like that. And in fact, they're not allowed to do so. So we're certainly not from now on, now that the Act's going to be enforced. And so that's also an interesting potential shift, because then the question arises, well, how is that to be funded? And if the local authority is responsible for the IDP, you can see how much more inequitable it might become if they're responsible for the funding of that provision at a fee-paying school. And it may be that that's what's behind the question. I'm not sure.
I could take the question. I think someone asked about, are we still looking at efficient use of resources as a test in relation to securing ALP, and whether that's still the case and how that will work in terms of non-maintained school age settings, which are parental choice. In relation to that question, I think the test in terms of what would have been part 4 it relates to the what's referred to there as the efficient use of resources, but it's not necessarily in relation to the ALP, but more in relation to the placement in general that's being looked at. Usually what would happen is that if a parental request is for a maintained school, the Schedule 27 of the Education Act 1996 sets out that that school must be named as long as it's suitable to meet the child's needs and his or her attendance would be compatible with the provision of efficient education for the children with whom he or she would be educated, and the efficient use of resources. So in terms of the case law and that has already been in place, as far as I understand it, and I'm aware that would continue to apply. And of course, it would be developed in accordance to any new changes if necessary. But in relation to the general principles that would be applied in terms of parental choices, etc., that would continue to apply. And what needs to be taken account in terms of efficient use of resources is particularly that if a parental preferred provision is a bit more expensive, that's not an automatic barrier under Schedule 27. So what needs to be done in that kind of situation is that the local authority, or subsequently the tribunal, must balance the statutory weight given to the parental preference against what would be the extra cost in deciding whether that extra cost is, in quotations, inefficient. So when looking at that, there's case law about costs against extra benefit, etc., that would be looked at in terms of that. and the tribunal, well, the local authority, if it doesn't get that far, but consequently the tribunal would look at that balancing act. In terms of, I think, the second part.
Can I just come in there? Sorry, Abla.
Yeah.
Sorry, I just wanted to say I think Abla's absolutely right in what she said. At the moment we have the test under Section 9 of the English legislation. I would say the wording of that is almost directly the same as what's in Section 51 of the new Act, which is the duty to favour education for children at mainstream maintained schools. And that again refers to the provision of efficient education for other children, just trying to get the I think that the same case law I think will apply in terms of Section 9 of the Education Act. Sorry, Abla, I've cut across.
No, fine. Yeah, that's great. Yeah, you pretty much finished off. Yeah, no, but I was going to say thank you.
Can I just add to that as well that one of the other interesting developments is going to be that the code requires a person-centered process insofar as the decision-making is concerned. And that might be taken, and again, we'll have to see how it's interpreted, but that might be taken to show that the focus on the individual child and that child's needs and provision required to meet those needs is going to trump the sort of criteria that are set often by local authorities when deciding how to balance their resources against the needs of all of the children in their area. There's always that conflict between the individual child and the local authority, of course, trying to do that. But it seems to me that because of that person-centered approach, that's going it's going to have to be added into the process, and local authorities are going to have to show somehow within their process they've not just taken into account the criteria, which of course I know they wouldn't just do that, but they've also very much looked at the parental views, the child's views, and done it in the way that is required by the code from now on in. And that may be a slightly different dynamic. We will wait and see.
I might steal an easy question if that's okay. So someone has asked, if a child has significant health need and requires support but no learning needs, will they need an IDP? I would say no, they don't need an IDP. For example, if a child is in a wheelchair, of course they're going to have duties are going to be owed to them under the Equality Act, which is then capable of a claim to the tribunal if there's an alleged breach of the Equality Act and those duties, but it wouldn't be an IDP.
Another very interesting question is about the duty to decide, and the question is, what is the time frame that an existing IDP can be reviewed when an Immersion new ALN is noted? And I'm not sure there is specifically a time frame for that, because obviously it's a new issue that's being bolted on, and I suppose the classic example of that would be a child that has been showing certain difficulties, but then there's a diagnosis which rather firms things up or suggests that it's a different course than that which had been considered up until then. And it seems to me that there's still a requirement for annual reviews, is the first point, and so some of this should be picked up on those and within the timescales for those. But if something is arising that is clearly a new additional learning need, it seems to me that there will then have to be an early review, and it would go into the review process. I don't think, given there's already an IDP, that the original decision-making timescales would apply, because that is only as to whether a child has additional learning needs and what the provision is required to meet that, unless anyone else has any contrary views, and I'm aware that they may have. Right, anyone else?
So I've got another couple of questions. One is, is a PRU seen as a maintained school or a local authority? I think a PRU is just a PRU. It has its own sort of section within the code. It's treated in its own specific way. So I don't think it fits into any of the other categories. And I think it is what it is, sort of thing. Someone has asked a question about education otherwise than at school. Again, there is a provision, there's a whole chapter in the code dedicated to IOTAs. I think the answer is that it's quite complicated. In any event, with regards to children and young people receiving education otherwise than at school, Chapter 18 in the code touches upon this. The duty to decide whether or not a child has additional learning needs still applies to someone who is educated otherwise than at school. And when a young person is educated otherwise than at school, which is not a PRU, and it's brought to the attention of the local authority that they have ALN, they're under a duty to decide. And that duty and the exceptions to it and related duties, including the duty to prepare an IDP, is discussed within the code as well. So if a child or young person already has an IDP prior to them being educated otherwise than at school, and if it is maintained by a school, the duty to maintain the IDP will cease if the child or young person ceases to be a registered pupil. When that's the case, it's the local authority which is likely to be subject to the duty to decide whether the child or person has additional learning needs. And if the child does have additional learning needs, the duties to prepare and maintain the IDP are likely to apply then, and it's the local authority that bears the brunt of that. And I say that more detail is in the code, but I think that sort of hopefully answers that question.
So there's also a question about post-16 college in terms of assessing that a young person has ALN as they require additional learning provision. Does the member of staff have to have any specific qualification that enables them to make that judgment? And I'm sure any additional comments will be added to by the rest of the panel. But from the information that I've seen in the code, and this is also addressed in Chapter 16 of the code, but probably not to the level of detail that that question particularly requires. But as part of the process, and my understanding of the process is after, of course, designating a person who's called the designated coordinator, which is a person who's obviously responsible for coordinating the actions required to make a decision about whether the person needs whether there is one required, whether an IDP is required. What would happen at that stage is that you would first of all notify the person, obviously getting their consent as to whether that decision could be made, but also then look into what has been reported or what is known about what their needs are, so that any relevant professionals can then assess accordingly to see what the extent of the level of the needs are and the extent of the provision that would then be required. So that usually, as I'm sure everyone's familiar, includes a range of either an educational psychologist and occupational therapist or speech and language therapist, because usually when it's being brought to the attention of a further education institution, there's usually some kind of indication as to what the need relates to, and to look into it further probably would require an assessment by an individual who has expertise in that particular area. And for that, from my understanding of a new code, for that to be coordinated by the designated coordinator. And there would also be a meeting, an initial meeting with the young person to discuss that process and the consent and the consequences of that.
Another question I've seen is, does this mean that the local authorities must pay for the advocacy? Simple answer is yes. It's similar to the provision, as I said earlier, for adults in the Social Services and Wellbeing Wales Act. I think it's section 180 something, but for advocacy for adults. It's now that it's also there for children and young people. So yes, local authorities must pay for the advocacy. Someone else has asked about individual education plans. Will teachers be writing these in addition to the IDP document? Will IDPs be updated termly? Question number one, it depends on which age cohort you're dealing with. So if you're the new age cohort and you are the IDP cohort, then you will just be doing an IDP. We're ending this IEP school action statement thing for that cohort. So the teacher, well, the teacher won't be doing the individual education plan. It will be the IDP document. If, however, you are in the cohort, or you're teaching the cohort where they're still on the old system while this 3-year transition is taking place, then yes, we will still have the IEPs, the school action plus, and the statement until we get to 2024 and the transition phase is complete. And then in terms of question number 2 there, will IDPs be updated termly? The Act provides for it provides review provisions, and I think it's 12 months minimum, but if there's any significant change, and I don't think that's the exact wording, I can find the exact wording in the provision in a second, but then it basically triggers a new duty. So yeah, just coming back on that, this is Section 23 of the Act. The first review period of 12 months is starting on the date in which a copy of the plan is given. Each subsequent review period is a period of 12 months starting on the date during the preceding review period. But I think there is provision to revise that plan during that review period if there's effectively a change in the level of need. So that is section 23 where you find the review periods, but basically 12 months, but yeah.
All right, if I can take one right at the end of our list at the moment, or the list so far, what sections of IDPs can be taken to appeal? The answer to that is in section 70 of the Act, and the answer is it's very similar to the current position, but you can. I'm going to run through them. I think it's probably easiest. You could appeal to the tribunal against a decision by the governing body, whether that's school or a further education institute or a local authority, as to whether, in fact, the individual has additional learning needs. You can appeal against whether it's necessary to prepare and maintain an IDP. You can appeal what used to be Part 2 in terms of the description of the individual's needs within the IDP. You can appeal the learning provision, so what used to be Part 3 as well, and that it will also include, it also includes the school named in the IDP as well. If there's no school named, that also can be subject to appeal. A decision, if it should arise not to revise an IDP, also can be appealed. A decision not to take over responsibility for an IDP following a request to do so can be appealed, and that's again part of the process whereby I suspect that any friction between local authorities and the schools and FEIs is going to be dealt with. A decision to maintain, a decision to cease to maintain, which of course also used to be part of the old statute. A decision that a governing body of a maintained school should cease to maintain, and a refusal to decide a matter, in that there's been no material change. So you'll know that one of the things which is all of these providers are able to rely on is if there's been no material change, they can make that decision and therefore not write or rewrite an IDP. But in fact, that also can be subject to appeal. And one of the most interesting things which is going to arise, I suspect, in relation to young people in particular, is whether they have capacity, because local authorities are going to have to decide whether young people have the capacity to understand the issues to do with IDPs and also to understand documentation. And if there's any doubt about that, first of all, the local authority is supposed to make that decision, and I don't know yet what the basis or what they're supposed to take into account to come to that conclusion. And then if failing that, that also can be the subject of a decision from the tribunal. And at the moment, I'm not aware of regulations which specify what has to be taken into account. And in particular, I would have thought that both the local authority and the tribunal are likely to want some sort of expert evidence as to that, in relation to capacity to decide those specific matters. And so again, watch this space. I think it's going to develop as we go on. Any other takers for questions?
Sorry, I'm just reading through them.
I know there are, I have to say, an awful lot of questions, which is marvellous, as I say, but we're juggling with them. Now, one question I have seen, that once it's all in effect in 2024, someone has asked, am I correct in thinking that school action plus cease on the ALN registers? Will the codes be replaced with school IDP/LA IDP? Yes, that's the intention as I understand it. The IDP, whichever version of it is, the school version or the local authority version, is supposed to replace all of that. And it's supposed to be also, I think, going back to the original intentions, a living document, so that it's meant to be being added to, if necessary, as time goes on and the needs of a particular child are changing, as it were.
Just picking up as well on a question about PRUs. The question was, who is responsible for maintaining an IDP for a pupil at a PRU? So it's the management committee that has responsibility, and the functions that sorry, I'm getting my words mixed up. The duties and functions that are placed on governing bodies of maintained schools effectively apply to the management committee of a PRU. So it's the management committee that would have the responsibility for the functions in relation to the maintenance of the IDP.
Okay, another question I've seen is, there are long waiting lists, CEPs or educational psychologists, and I don't know whether that varies from one area to another. I suspect it does. And the question is asked, what if you cannot get their advice within 35 days? I've been trying to see quickly, and I haven't been able to identify any way of extending that period. And it is more difficult if the local authority begins to think that a child has additional learning needs, because of course it's not just if it's brought to their attention, it's if it comes anyway to their attention if they think it might be the situation. So that might give a rather flexible start date. But if there's an actual referral or request, then there clearly is a start date, and then you have your 7 weeks to get on with it. And I think it's a must. I don't think there is wriggle room at the moment. And this, I think, goes back to the need for local authorities to review within their particular areas that there is sufficient provision for additional learning need to be met. Because clearly, if there are insufficient educational psychologists in the area, there's got to, then that is not being provided by the local authority, and they'll be in breach of their other duties. So this is exactly the sort of area where local authorities should be planning ahead, and indeed making sure they've got sufficient provision in terms of their own funding arrangements to ensure they have an adequate number of educational psychologists. And it may well be that we've now got a greater need for educational psychology input than we had previously, and that we're going to need some more. We will see as again as time goes on.
I've got another question that's arisen, and it's in relation to I think it touches on two different questions that have been asked in relation to additional learning needs. So someone has said the test of whether a child has additional learning needs or not, and whether they require additional learning provision, is extremely difficult to judge. Whilst this is clearly a two-step process, arguably this will differ from school to school depending on what is considered universally available in that school. Some schools will offer extremely complex provision universally and then not develop an IDP for the child, and consequently the child and parent will not have the entitlements from the Act and the Code. Will the reconsideration duty become the new pinch point for local authorities, and an unintentional ongoing stress for families having to continually monitor the non-statutory provision? So what I would say in terms of the test of additional learning needs, a child has additional learning needs if he or she has a learning difficulty or disability, so i.e. comes within the definition section 6 of the Equality Act, which calls for additional learning provision. Additional learning provision is where it's different from that made generally for others of the same age in a mainstream maintained school in Wales, mainstream institutions in further education sector in Wales, or places in Wales at which nursery education is provided. So I don't think it is a test that can differ from school to school, because it is what's generally available for mainstream students in Wales. So I would say that I appreciate it's always a matter of fact and degree with anything like this, because people aren't, it's always going to be a matter of fact and degree as to whether someone's got additional learning needs, in the same way that it was with regards to special educational needs. So but what I don't think is right that you can change the test depending on which school you're at, because it's quite clearly what is generally available at mainstream maintained schools.
Okay, am I on mute? No, I'm not. Can I just go to another question which relates to this capacity issue? Let me see if I can find it again. Someone has said this: I'm concerned about young people still in school, under 16, who have behavioural issues and refuse an assessment. And the example then is an individual with ADHD. I absolutely agree. That is a real problem. The capacity, I think it's even more of a problem if you consider that the first port of call for making a decision about it is the local authority, who may well have a conflict situation on their hands in terms of what they think is appropriate, and what the young person thinks is appropriate, and indeed what the parents may think is appropriate, all of which they've of course got to take into account. But it's dealt with in Section 84 of the Act, and part of that, as I said, is for the local authority. It's a must. The local authority must decide whether the child has the capacity to understand the subject matter, and that means it says at subsection 8, the capacity to understand A, information or documents that have been given to a child under this part of the Act, and B, what it means to exercise the rights conferred on a child by this part, and that's all to do with the rights of appeal, etc. And it is going to be really difficult if you've got a youngster who has capacity and who is making a decision which is, let us say, plainly not in their interests. But that goes to the heart of what capacity is all about, I'm afraid. If you have capacity, you have the capacity to make a decision which is a poor decision and which is which is a decision not in your interests, as in one of the dear old cases many years ago of the chap who refused, because he was there were capacity issues, to have his leg amputated. He had capacity, he didn't have it amputated, and he lost the leg. It was patently a very poor decision, but he had the capacity to make it, and therefore has to be allowed to make it. So, although I think it may, the result may be quite harsh for some young people and may not help them at all, I think if they have the capacity, then they can make that decision, even if it's patently not in their interests. I don't know if Laura can help with this one. There's a question again about PRUs, and it is some of these which are particularly interesting. These sort of additional areas, as it were, which is not going to affect many pupils, but affects those pupils and young people that are concerned rather severely. The question is, should all pupils attending a PRU have an IDP, as it is a specialist provision? And the answer is, you just go back to the basics. Does this child or young person have additional learning needs? And is provision, which is always part of the decision making as to whether they have the need in the first place, is provision required to meet that need? And I don't think the fact that they're a PRU actually affects that adversely, unless this particular section on the PRUs alters that, which is why I'm saying, I don't know if Laura can help at all.
So my view on that is that, I mean, my understanding in respect of PRUs is that children and young people don't just go there if they've got a learning difficulty. They can go there for a range of behavioural difficulties as well that may be brought on by their social environment. Or so I would say that it's not mainstream provision, but is it as a result of a learning difficulty or disability? I'm not sure. So I think, again, I probably have to have another look at that, but I would say Mark's right in that you've got to go back to the basics and consider the definition of additional learning needs and additional learning provision. And I think it's the learning part of that that I think is particularly important when considering the PRUs.
Yes, thanks, Laura. Just going back to capacity again, someone else has followed up what I've just been saying is, with this, is capacity not specific to the circumstance rather than general? Yes, of course it is. And that is why the statute specifically says this in this section: the capacity to understand the subject matter means the capacity to understand informational documents given to the child, or what it means to exercise the rights conferred on a child by this part. So it's narrower even than, as it were, capacity to litigate or well, the capacity generally. It is specific, and specific it seems at the moment to those questions. But I suspect that the approach will be that if a child generally has no capacity for whatever reason that might be, that it's going to inform those answers to those specific questions. But you're absolutely right, it has to be specific, not general.
I'm just looking at the time mark. It's 25 to 3 now. I can't remember when we said we'd finish.
No, I can't either at the moment, unless anyone else wants to answer one of the questions.
We've got, it's set for 2:45, so you have another question.
Another few minutes, if we can actually find one that we can do. All right.
I've got a question again about capacity. Who will make the decision as to whether a child or young person has capacity? There are significant levels to a cognitive capacity, which I think should be assessed by a psychologist rather than someone who has a general knowledge of capacity. So one of my areas of law is mental capacity law, and I completely understand the concern here, because we have Section 12 doctors or specific social workers or nurses that have been trained to do capacity assessments with regards to adults in the DOLS regime. I'm just having a look now at the regulations, which is the Equality Act, Capacity of Parents and Persons Over Compulsory School Age regulations. When a person over compulsory school age lacks capacity is regulation 4. When a person over compulsory school age lacks capacity at the relevant time, it does mean capacity within the Mental Capacity Act, but what I can't see in these regulations is who is determining that. So I don't know whether we're going to have to cross-refer to the Mental Capacity Act for more answers there, but it's not, I don't know whether anyone else agrees, but I don't think it's clear from the regulations as to who is making that assessment.
I got cut off for a while there, and I was about to answer a question when I did get cut off. So I'm just back again. So before I do launch into answering a question, I don't have the list in front of me anymore since I got cut off. So can I just check with the other panelists? It was a question which I don't remember the exact wording for, but it was about if provision can be met through the school's resources, whether there needs to be, you know, I think additional learning provision or plan put in place. Has that been answered already?
Yeah, I think Laura did.
I'm going to have another look. So I think there were 2 questions that were similar. I'll have a quick look now.
Yeah, because I think I was just going to refer to the definition of the ALP. So if you've already done that, and
yeah,
also...
I did do that. Yeah.
Okay, no worries.
Someone's asked, would children being educated at home be entitled to an IDP? Yes, if the duty to decide is triggered, and then the local authority decides, and then if the local authority decides that a child does have additional learning needs, then yes, an IDP, the duty to provide and maintain would be in place there, and that's the education of the otherwise than at school chapter that I referred you to earlier, which was the chapter 18. Someone else has asked, can a PRU be named provision on a pupil's IDP? I would say that's more the placement as opposed to provision. So I think it would go in the placement box, the bit of the IDP which is the equivalent to the Part 4 on an SEN statement.
Yeah, I can just go back to the education otherwise. That is 18.11 in the code. And you'll see that the local authority must decide whether the child or young person has additional learning needs, unless one of the exceptions you've been taken through already applies. So it's the code really helpfully actually sets out some footnotes which tell you where the duties come from, whether it's the code or the statute, although they both have statutory force. But also another innovation is that it sets out various words in different colours. And one of the ones it sets out is must. and must is always in red. And it's really helpful as an innovation in terms of how you read the document. And the same, I'm just going to say at 1810 in terms of proofs, again, if it comes to the attention of the management committee of the PRU, and for these purposes, what that section of the code specifically says is that PRU is within the definition of a maintained school for the purposes of the ALN system. And its management committee has responsibility for those things that a governing body at a maintained school would have responsibility under the ALN system. So I'm afraid there is a real onus to be placed upon PRUs in relation to this. And if they again think that, that there's a child who has additional learning needs, the management committee must decide whether that pupil has ALN, unless one of those exceptions that we've been through applies again. So the intention is that wherever a child is, that the local authority has, or the governing body must see whether there's provision required and how it's going to be met. So it's quite stringent. The other thing I should also perhaps mention, which I don't think we've mentioned strictly in terms of local authority duties, is of course there is a whole section of the statute which refers to children who are in local authority care, and those are not children where an IDP is maintained at all by the school. The onus is completely placed upon the local authority, no doubt because they will be responsible for other planning for that particular individual person or child, but it is the local authority that does the IDP and maintains it, etc., whenever there's a child in care. Has anyone else got anything else to say upon questions?
Just got one, which is about advocacy. I am seeing contracts for child and young people advocacy for educational complaints, but I thought they might need advocacy for understanding and engagement. My reading of the code is that it's much more about disagreements as opposed to understanding and engagement, although at each time a statutory step is taken, i.e. duty to decide, duty to prepare an IDP, maintain an IDP, etc., there should then be a referral to advocacy. So yes, they must make arrangements for the provision of independent advocacy services and refer children or young people for whom it is responsible to advocacy services, and refer any person who is a case friend who is responsible, who requests independent advocacy services. But independent advocacy services are there really for when a child or young person is making or intending to make an appeal to the tribunal, considering whether to make an appeal to the tribunal, or taking part or intending to take in part arrangements for avoiding or resolving disagreement. So, albeit I agree that disagreement is quite wide, I think that the advocacy is really aimed at resolving disagreements as opposed to just helping with the provision of information.
Right, and I think this time time is up. So I'm going to bring this webinar to an end. Thank you very much all that have attended. We've had a fantastic turnout for this, and we're very grateful for that. We will see if we can field some more questions after the event in one form or another. I'm not sure how we'll do it yet, but we'll find a way of doing it. And we will see, I hope, all or most of you next Wednesday at 1 o'clock for part 2. Thank you very much, everyone. Good afternoon.
Thank you very much. Take care.